Morning, everybody.
Good morning.
Morning.
So it is 9 o'clock. So why don't we get started and call the meeting of August 27th, 2024 to order. First order of business is to review the agenda. Are there any agenda additions? MJ?
I would like to add 2 reconsideration requests in between number 3 and number 4. And I know it's last minute, so if we have to, we can pull up the file.
Yeah.
While we do it.
Any other additions? I would entertain a motion to approve the agenda then.
I'll make a motion. We approve the agenda as presented,
Second. As amended.
as amended. That too.
Second amendment. Thank you. All those in favor of approving the agenda signify by saying aye.
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 Lynn? Thank you.
And Lynn, did you find it, Lynn? It's in the August.
Yeah, I have it open. Yep, thank you.
Make sure you found it in my last minute scatter.
Looking at the minutes next.
These were not in the original packets.
Right.
They are in your packet today. So if we need a couple minutes, sorry about that.
Folks want to take a minute and just quickly look at them?
Yep.
You get an extra packet here.
Oh, yeah.
I know I came in on time.
No, I did. I forgot when you walked by to give it to you.
Got chastised when I came early for something.
Dean was lamenting about you being late today.
I was late. I was right at exactly on time. I waited in the parking lot.
Everybody had a chance to look at them?
Mhm.
Would entertain a motion to approve them.
I'll make a motion. We approve the minutes of last month's staff meeting.
I'll second.
Thank you. Any changes suggested or corrections? All in favor of approving the minutes as written, you signify by saying aye.
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 Thank you, Lynn.
Aye.
Got a couple of people coming from DOC to review ICOTS with us.
Who we have?
I know one of them is Mark Devon.
Mark Devon, yeah.
Yeah.
Not yet.
There he is.
You're probably looking for me,
Yes.
or should I sit any place?
Anywhere you want.
Good
I'll
morning.
let her know that you're over
Good
here.
morning.
I emailed her, she didn't email me back either.
No, she's been out.
Good morning. Hey Patty, how are you?
Good. How are you?
Good, good. What's going on down there?
Living the dream. How are you?
Absolutely,
Dave.
every day.
That
It used to be a safety today without you being in the newspaper, you're doing fine. haven't seen
he
that
was
for a
by
while.
himself.
Correct.
Wasn't
Oh,
his
yeah,
name
yeah.
Dave?
Dave, the guy that used to bring everybody.
Yes.
Yeah.
Saw him at Dunkin' Donuts.
Did you really?
Yeah.
Wow.
Yeah. He looks the same.
Bellini? Is that who you're talking about?
No,
Dave?
no, no, no.
Oh.
He used to work at Burlington P&P. He was always sort of the gatekeeper for bringing people.
Oh.
Dave Bellini.
No, not
No,
Dave Bellini.
No, I can't. If I hear his name, I'll know it.
Oh, I don't remember
I
another
knew it
day,
was
but-
Dave. He rides a motorcycle all the time. Big guy.
Motorcycle Dave.
Big guy.
Yeah.
And I can't remember his last name. But he always let people in and
Yeah.
he was good at coordinating
Yeah, he
everything
was.
we
Good
did.
friends with Courtney Gurley.
Yes.
Yeah.
Yeah.
Okay.
The only thing I
If you
can
think of his
would be
name, tell
Jonathan
me,
Robinson.
because it's gonna bug
When
me.
you say Dave in Burlington,
It's
Bellini.
Bellini's the only thing
Oh,
that
yeah,
comes up.
Yeah, we know Dave.
This was even before COVID, when we were going to the P&P office.
Right.
The only body I
In
can
our
think of is
hearings?
Jonathan Robinson.
No, it's Dave.
Okay,
Big guy, Steve. John Test.
Bald.
yeah.
So we're waiting for anyone else?
Lori's supposed to be coming,
Okay,
but I don't know if she is tied up in something.
She wasn't in her office. I did find her office.
I didn't look to see if her car's out here.
She doesn't email me back, so.
All right, so I can kick off if you
yeah,
like.
go ahead.
So for all that some of you know, this is Mark Devens. I don't know your official title.
I'm a field operations manager
Okay.
with DOC.
Yep.
So
So Mark over his is over here. It came over to join us to give us a little bit of give the board a little bit of an interstate compact overview, and also an opportunity for you all to ask questions about the interstate compact. And I don't know if we have some new board members. I don't know if you want folks to go around.
yeah, it wouldn't hurt. Some people I don't know, some people I've known forever.
I'm Katie Aiken. Recent, probably like just last few months, like 3 months or
It's in
so.
February, yeah,
So yeah,
you're the same. Yeah.
Come aboard.
thanks.
I'm Samantha Drake and I started in May.
I'm Giffen. I think I started in 1984.
A few years before me.
Yeah, couple.
Wayne Dangler, I'm an intern thinking about taking the job.
Right.
Pat Boucher. I've been on the board for a long time.
Yeah, me too. Dean George. Nice to see you, Mark.
I'm Carla Becky and I'm in the office.
Seen your name float around, but
Yep.
that's about it. So.
That's Lynn up there.
And Lynn Carolio.
It's
Look at that.
Hi,
Very
Mr. Leo.
good.
I've been on the board about a year and a half now.
So in years past, Mark, some of us went through the ICOTS training, but a lot of the newer board members have not. And in the last few months, it seems like we've had several issues with ICOTS violation hearings.
Right.
I think there's some changes that might be helpful for us to understand a little bit and maybe just review some of the.
Yeah, the big thing is that changes really haven't occurred. Wholesale changes really haven't occurred all that much. I think it's a complicated system. And if you don't use it all the time, you're going to flounder through it a little bit. And it's Mary Jane's good at, she understands it. She understands who to call if she doesn't understand it.
Hey, Lori.
Sorry. Chasing Mark and Mark's here.
He said you were probably chasing him.
I waited and then I was like,
No, you're fine.
maybe I'll go see her.
Your back will be to
I think
it.
we crossed each
If
other
you
in
sit there, your
past.
back will be to it.
Sort of get out of the way of the camera. How about that? Sorry about that. Sorry to interrupt.
Oh, no, you're fine. We just started.
Doing a little ICOTS overview. So the background on the interstate compact is it's a federal rulemaking. It's based on federal rulemaking, which gives it the weight of federal law. State of Vermont in statute has agreed to comply with the rules of the compact. So the national office, along with the member states, which all 50 states plus a couple of U.S. territories, Puerto Rico, Virgin Islands, Guam, all agree to be a part of the compact. And what the compact does is it allows us to take supervision from one state and transfer it to another state if the other state is, for instance, we use New Hampshire, New York, and Massachusetts are our primary transfers. People go to Florida, they go to Arizona, they go Montana, as we found out recently.
Yeah.
So what it allows us to say, okay, this person is a resident of the state of New Hampshire. We can then do an intake from probation, parole, or however we get them, except for furlough. They have to be on probation or parole, and let them return home. And in agreement with that, the individual agrees to be supervised by that other state based on that other state's rules. So it allows for instance, in Vermont, we have very different rules than a state like Florida. Florida, if you go to Florida, you'll have 50 conditions of probation. We have 25 at max. And that's with a really heavy duty case. We're going to get 25 conditions. You guys give 11 standard and then 6 standard. Well, it's a little, it's 6 conditions, but there's multiple versions. There's multiple stages of a condition. So, but 6 conditions is a good example. We have 6 conditions and you might give 2 or 3 additional conditions. Might require programming or whatever. So what happens is, so we transfer that. Let's say we have 9 conditions of parole that you guys said, okay, we're going to do parole. We're going to say there's a good plan to go live with mom in New Hampshire. New Hampshire can then review that case and say, okay, if this was a New Hampshire case, they would have these conditions. And they may be a little different. They may be in addition to our conditions. So they can add those conditions through the compact.
So Mark, we've always been told that when we set conditions for somebody we're paroling through ICOTS, that whatever conditions we set are just recommended for the receiving state.
Not recommended per se. They're still so the receiving state is still required to say, you violated a condition. This is how we dealt with it. We either told the Vermont to take them back or we handled it ourselves. So they can do sanctions and whatever their state does, they can do those things in response to non-compliant behavior.
So if we set some conditions and then approve the parole for ICOTS to another state, they will have to include
those conditions as part of their supervision practice.
Along with their own.
They can add their own. Now, so we don't add any. We add very few conditions when they come in state.
Really? Okay.
So because generally,
you also get a list from that state.
Yeah. So we'll get the actual probation or parole order from the other state, and we'll say, "This is it." We may add a condition to if there's a victim in the nearby town. We may add that condition saying no contact without permission or no contact until we speak with that person as to whether she wants contact or not.
So Mark, all the conditions we set will be followed by whatever state we send them to?
Yes.
I did not. Okay.
If there's a condition that's not imposed from the sending state, but DOC wants it included, do they have to come to the parole board to ask for that condition, or they just can automatically
As
apply it?
part of the compact, they're allowed to add that condition.
Okay.
So, it gets a little tricky when there's a violation.
Yeah.
So if they've added a condition on the other end, we are required to respond to a violation of that condition. Now, how we respond, it's
So
really kind
in
of up
some
in the
cases,
air.
Mark, when we set conditions to go out of state, we'll add a special condition that says you must abide by the conditions set by the state of blah, blah, blah.
Yep.
So if it comes back to us, where they have violated a condition set by that receiving state, say it's New Hampshire, then it would be a violation of our special condition 18 as well.
Correct. Yeah, that's a great way to get past that sort of. So it's been argued by non-AG attorneys that adding conditions is illegal. It's not illegal. It's in the compact that they can do that. So protecting yourselves as a board by adding that condition is a great way to get around that. If we know he's going out of state, and a state like Florida, for instance, is absolutely stunning, the number and type of conditions they will add to a probation order, especially for like a sex offender. A sex offender in Florida is going to have literally 55 conditions of supervision.
Wow.
And they will add them all.
That
And
would survive.
it will talk about, they have mandatory electronic monitoring. And if you reach a certain threshold with them, they will treat you as a sexual predator, which under Florida law elevates you like to the top of the food chain. And yeah, so we've had sex offenders go to Florida, spend a week there and say, I'm going back to Vermont.
Yep.
So Just
They
because,
post their pictures on every.
yeah, they mandatory electronic monitoring, which they pay for on a
The
crazy
offender
price.
pays for it?
Yeah. At a crazy price, $150 a month or something like that.
Whoa,
So where does that money come from?
yeah,
Probably coming out of some food budget or something like that.
Yeah.
So
yeah.
it's different philosophies for different states, and so the compact, when there's a violation and we're bringing them back, that is when things really get firm. As we learned in Montana, when a person is arrested in the receiving state, we're required to complete a PVC hearing in the other state before extraditing them back here. That didn't occur in that particular case. I think we were all of the opinion that was an oversight.
Yeah.
I think we've put some things in place, at least on our end, to try and identify those cases. We do label them different. We do, when we send a person out of state in OMS, we do label them. There's a legal status that says ICOTS to another state. If it's an older case, it may not have that. So Morgan, before extradition, is now emailing Ricky and I and saying, is this an ICOTS case? For every case she's extraditing. So we've kind of.
I'm trying to catch it a little bit too. When I get notice of retaking of availability to pick up and so forth or arrest, I let Morgan know too if I know it's an ICOTS case.
Now, if there's a new criminal charge in the other state, which raises arrest and extradition, the new criminal charge counts as the PPC hearing. So when they do the arraignment and the conviction, that we can avoid the PPC hearing in that case. So, like I said, it gets complicated and it's best if we all talk ahead of time and we run into much fewer problems. We're our own worst enemy sometimes because there's a PO involved in that case that easily could have short circuited that.
Yeah.
But again, you don't use it. You got 1 or 2 cases a year. You should not be expected to have full knowledge of everything. So Ricky's the point person, Ricky Plank. I'm not sure how many of you have met him before or had a conversation with him. Yeah, he was a PM in St. Albans for a long time. He took Donna Pratt's place when she left in 2019, 2020. It was 2020 because we were right into COVID after he was hired. So he's been around since then, and he's very knowledgeable. If you can't get a hold of him, I obviously have the knowledge to do some work. And Dale.
So when that state decides that they want Vermont to retake this individual, whatever hearing was conducted would be included in that paperwork.
So we would, so yeah, in the interstate compact system itself, there's a place for everything. So on the violation report that they would send to us, we would send a response back saying, please conduct a PPC hearing. They would then respond to that with the PPC hearing results attached to it. So then you guys would get that in your hearing saying this was what the hearing officer found, just like we would.
We've never gotten any of that. We just get the violation report requiring retaking usually from the POs.
Yeah.
So just a heads up.
We got some things to iron out.
I know.
Yeah.
So for sure.
But absolutely.
And you guys, that should, yeah, I mean, that should be when you guys are getting a violation packet from the PO, that PPC hearing report should be included in it.
Yeah.
Okay.
So, and if you're not getting that, let us know and we'll
I'll
make
keep
sure
a
that
lookout.
gets out there. I can't guarantee you're going to get them all though. We'll ask.
I try.
I don't want to set the expectation too high on that.
If someone that sent them through ICOTS to Vermont, is that what we do too first? We do.
You don't get to play with that one at all.
No.
Oh,
That's
Yeah.
us.
So the interstate compact allows for states to go to the other state, pick the person up and bring them back. So if we have a case from another state, we do the PPC hearing as a hearing officer would in the facility. They do the findings. Dave Turner does all of ours for ICOTS cases. So They will do a PPC hearing. Do his write up his results. We will send it to the other state and then arrange for that person to get picked up. So you guys don't have to.
So we don't
play with
see
it.
those.
We don't do it.
For anybody wanting to, I don't know, a PPC hearing is basically a preliminary probable cause hearing. Just a,
Yeah, it's an arraignment basically,
Yeah.
or
Yeah.
a non-court case.
But as you said, if they're charged criminally or convicted.
Yeah.
There's no need for that.
this should all be worked out
Yeah.
prior to it even coming to the board. The
Yeah.
board. I think the biggest thing, Mark, that we've been dealing with and we've been seeing is once they're back in state, we schedule the violation and more about how to respond to that violation. What are the options? Can the other person go back, apply and go back to the other state? What is the plan? Can they be paroled in Vermont at that point? When the other state closes their interest in the case, but the board hasn't held the violation hearing, what are the rules around that?
So
That's kind of, and I
Once-
will look at Lori too, because we kind of went down this road
So
recently.
there's a couple of avenues in which we can approach the other state with. So if we know, for instance, ahead of time, that the parole board is unlikely to revoke parole, and that's a guess for the most part, because you can get in here, you can
Yeah. We don't know.
talk to the guy, and the next thing you know, you're like, I'm not really comfortable with him being on parole anymore, and that's it.
Yeah.
So if you bring a case in and there's a discussion about the merits of the case per se on your end, say this was a violation, but is it really a violation where we're going to revoke and keep in jail for the next 2 years? We can talk to the other state about him returning to that state pending the violation if you were to release him. For the most part, once we retake them, they're ours again. And they aren't allowed to go back to the other state until the violation is resolved. So once we bring them back, now everyone keep in mind that the Montana case, for instance, was an $8,000 extradition.
Yeah.
Most of them now are $4,000 to $5,000 extradition. So if we've reached that point of bringing them back in that manner, then we're probably asking for revocation.
Yeah.
I know we didn't in Elizabeth Gagne's case, but I think that was special.
So maybe just a clarification, in many cases, the information that we're getting is that the person's been returned. They have no ties to Vermont. They would obviously like to go back to that state if possible. It's sort of like a reset. Their parole is revoked because they've been ordered to be retaken.
Right.
With the idea that there would be another staffing and a review of whether they should go back to that state or not. And then subsequently, we would have a parole to that state hearing once that determination has been made. In some cases, we don't know if that's the case. The individual would like to go back, but we're getting information from DOC. Well, we're not recommending that they go back again after that. So,
Or like the one where they had lined up a treatment
yeah,
facility in the other state that they're just getting
that they,
Sent back from.
sent
they
back
were
from,
ordered
but
to
we don't know
retake
if
them.
they're even going to be allowed
Right.
to go to that one.
Yeah.
So the only
treatment
rule-
facility.
Yeah. So the only rule about sending them back to the state that they just came from is that the violation has to be resolved. Now, internally, if we're
when you say the violation, do you mean
Ours.
Your
the board,
violation.
not the criminal charge that may be pending in that state if there is one?
your part,
Okay.
and they shouldn't be, well, if it's a felony, they generally don't come back to us until they've resolved that charge in the other state.
Yeah.
Misdemeanors get a little squirrely because like with Gagne, for instance, they
Yeah.
dropped the charge and then sent her back to
Right.
us,
Right.
knowing that we could easily send her back to them.
Yeah.
But they would still have to accept her, right?
Okay, so let's talk about accepting.
Yes, I was just gonna go down that road because we had that come up in a recent one.
There's
too.
4 or 5 reasons, and I'm not going to try and name them all off, but I can tell you there's 4 or 5 reasons why someone can transfer the shell in which they transfer under.
Mhm.
And one of them is there's several of them that are what we refer to as mandatory transfers, meaning that if you meet this criteria, the other state has to accept you
Yeah.
unless there's a reason not to.
This is part of the compact.
Yes, this is all part of the
That
compact.
Vermont
rules.
has agreed to.
Yeah, so,
Okay.
and I can send you guys the bench book.
I know where to get it.
Yeah, so if you, there is a large
Yeah.
100 and whatever page book that you guys can review at your
Yeah.
leisure, and
Wow.
I would suggest you have a question, call Ricky or me.
The judges don't even,
Yeah, the judges don't.
Right.
they
Yeah.
can't even maneuver
Filter
that.
the questions through me and I'll filter.
So those, one of those criteria for transfer is family in the resident family in the receiving state. They define what a resident family member is, how widespread family is. For instance, it's generally considered mothers, fathers, brothers, and sisters. It can extend out to uncles or aunts, or you get into cousins, it gets a little less firm, so to speak, but it's generally immediate family. If you have an immediate family member and a good plan of supervision in the receiving state, they have to accept you. So the definition of a good plan varies from state to state. So one state may just say, okay, mom lives here, send them on down.
Does that,
next-
is that despite the number of violations they may have
doesn't-
had
that's
or
irrelevant.
recent
Yeah.
violations? Like none of
If
that.
you
matters.
have brought the individual back and they saw the board and you said, we're going to slap you on the wrist and we're going to send you back out on parole, they are immediately eligible for transfer back to that state.
So,
And it can't be used against them that they had multiple violations before.
so appeal brought up I think, and I don't know if it was a mandatory transfer or not. I think it may have been in a recent one that they also needed to be case plan compliant. And the PO was arguing that they weren't case plan compliant because we had to retake them. So does case plan compliance come into play?
Whenever a PO quotes something like that, you email me there.
Okay, I will. Cause I went looking through the bench book and I'm like, I see something about case plan, but
They have to be compliant. But when you've had a violation and the violation is resolved, they start over. They're now compliant again.
Okay.
So
Resets.
So it doesn't matter if they are revoked or continued on parole, it's resolved.
correct.
Because they've seen the board.
So
Okay.
DOC, if they've been revoked, can start the process of returning them.
Well, yeah, it's
Or if
obvious.
they
Yeah,
are continued on parole, they can start.
right.
So-
With Elizabeth Gagne, I don't know what you're going to do next week when she goes to see you guys. But-
she's not coming before the board. She's got a proposed resolution, but same thing. She
Yeah,
won't.
that's gonna get resolved.
It's gonna get
It's-
resolved.
We have been pre-planning that because we already know she wants to go back there. She has family there. And we're
So
ready to roll with that.
just
So
an extension of that, Mark, do you have, as DOC, do you have discretion over whether you allow them to apply for
yes,
ICOTS?
it is at the total discretion of the sending state whether a person transfers or not.
Regardless of their situation.
We could say to her, no, you're not going back there. We think you're better off here. And there's no right to transfer. It's at our total discretion.
So just as an aside to that, there are a number of cases where we're seeing the individual in the facility, no ties to Vermont, and they expressed during the hearing that they would really like to go back to where they're from. And so then we talk to the caseworker at that point and say, are you DOC looking into whether or not we're going to use ICOS to send this person from here to this other state? And then decide if they are, then we will postpone the hearing until that process is done. Or they may say, no, we're not going to. We want them to be in the community first.
No one in DOC should tell you if they're willing to put a person on furlough, they should be willing to put the person on parole and they should have already made the parole. That goes against everything people have been told. That scenario right there goes against what everybody's been told, which is the exact. So if they have a valid plan of supervision in another state, we should be ICOTSing that person to another state.
Yeah.
Without hesitation.
Dean, I just saw a nuance there. You mentioned you postpone the hearing until that gets.
Well, if there's no other plan, rather than deny parole at that point, and they're going to apply for acceptance by that state through ICOTS, we would just soon wait and do the hearing on that.
But it's gotta be a non-violation hearing, because if that violation.
Oh, yeah, no, this is
Right,
just
that's
parole
what he's talking
eligibility.
about.
This is eligibility. Okay, I
Yeah.
just want to be clear.
Yeah,
Okay.
absolutely.
Because they can't apply to go if it's pending.
No,
I mean,
no, this is just someone who's eligible.
Gotcha.
Yeah, the biggest issue is if somebody's from another state, but they don't have a plan of supervision in that state, that's where you run into problems. So that's where
Sure.
we do transitional housing and then
Mhm.
bring them out and
Yeah.
that deal, but it's not ideal. We would prefer people on parole.
So here's a kind of a supplemental question to that, because I had asked years ago, I asked this. It's at DOC's discretion to apply for ICOTS, right?
Correct.
Just DOC's. I just wanted, because that's how I respond to offenders who DOC says no to, and then they turn around and write to the board saying, please tell DOC to ICOT me. So I just want,
Can't do that either.
so I just
We
wanted,
don't.
so I just wanted to clarify that.
Battling
So
the mom and
everybody,
dad.
so if that comes up in a hearing, I just wanted to clarify it for
Yeah, yeah.
everybody.
Right?
So I mean, Mark, the PO should not be telling us, oh yeah, I'll look for ICOTS at the hearing, and then it should not be, it should have been done before, correct? So was it-
Sometimes we're as surprised as you guys are that their
Okay,
plan
that I
may
understand.
exist somewhere. So, and it may be a facility caseworker that he talked to and never talked to the PO about it. So
Anyplace
Yeah.
further.
Or it may be a last ditch resort that I've seen a few
Yes.
lately that they're pitching to the board, and the caseworker's like, well, that's the first I've heard about
Yeah.
it, because they're
Yeah.
not pitching that.
Well, that's understandable.
with the new questionnaire that they're being given,
Yeah.
if
It
they-
should come out in
it
that.
should come out in that. And if they don't fill that out, or I know
Yeah.
there's a couple people that have refused already to participate, so to speak. And then they'll show up to the
We
board and
deal with
say,
them.
I live with my mother in Maine.
Yeah.
No, you don't. Otherwise, I'd have a nice plan right now. So, any other questions? One thing, and I'm sure you've all heard this. Any warrant that we have to get from absconder in another, that flood supervision in another state is required nationwide extradition.
Oh,
And
All 50 states and 3 US territories.
50 states and 3 U.S. territories. And
wow.
we don't have discretion on whether we pick them up or not.
That new?
What's that?
That-
No, that's not new at all.
So you,
We don't have discretion over how long they have left. Like, I had to issue a warrant for somebody who had 2 weeks left on their sentence.
oh,
Yeah, so
It's the meters, not that make any difference, just the, okay.
the rule is the rule. Now, we've manipulated a couple of them here and there over the years,
We did during COVID.
where we basically gave them credit for time in the jail at the other state. And I don't know if we did it with that one or not. I know we,
I know we early discharged that one.
yeah, so,
One of them.
Yeah.
so, but we skirt the line of the rule when we do things outside of extradition.
Mhm.
We can get fined, we can get sanctioned for non-compliance with the compact. Now, we are not the biggest abusers of that system. So similar things like Montana did with Gagne, and they dropped that charge, so she was extraditable.
right.
So, and then didn't do a PPC here, of course.
She was smart.
Interesting.
Any other areas, Mary Jane?
I think the biggest one, I think, for the board are the paroling too, and then responding to the violation.
Yeah.
Those are what they really see.
Yeah, I know. Was there anything? I thought I heard something about You guys didn't know she was Gagne specific on this one, that you guys didn't know she was in Montana?
Oh, yeah. So, okay. That's a good one. So
Yeah.
she was paroled to Vermont.
Yeah.
And then when she was out on parole in Vermont, she was then transferred to Montana through the ICOTS.
Right.
And we had no idea.
So
So
we're not
she,
part of that process.
That's correct, basically.
yeah. And so she didn't end up having that special condition 18 that says you shall abide by all conditions set by the receiving state, which the board generally puts on for most everybody. So she didn't have that one because the board wasn't made aware, but so we don't know we don't technically know all the ICOTS cases,
Right.
but when we're asked to retake, I know them because I'm issuing the warrant and I get the retaking packet.
Yeah, I'm not sure why she wasn't transferred from the jail, frankly, because
She went to
all of her support's out there.
Yeah.
she went to Mandela House for a while.
Right. Yeah, they wanted her to
Well,
go
they
back.
closed the house, didn't they?
Yeah,
Yeah, it's no longer there.
right.
Yeah. So I
Yeah.
think that's the one.
Pretty unusual case, though.
Yeah, that was
Yeah.
way out in the
Yeah.
bizarre zone, frankly, because that was. We generally know when they're coming out of jail whether whether they have support systems in another state or not.
The other question I think came up that and Lori and I have talked about before is if somebody is out on furlough, whether or not ICOTS can be applied, because furlough is an extension of incarceration. Can the board see them to parole them to an ICOTS plan?
Yes,
And that was always a no for everybody.
you can't send them while they're on furlough, so they have to be on parole to
Right.
go. But
We can parole.
But it was always the main known of if you're on furlough, you can't apply for ICOTS while you're on furlough. You've got to get them paroled in Vermont first. So I think that's the.
No.
So
Yeah.
the problem, though, so I will say there is some states don't understand furlough.
oh,
Right.
So they see it as community supervision. And then, so we have timelines around when we transfer people with certain events. Leaving jail is an event, getting placed on probation is an event. So if we have somebody get put on probation, we have 7 days to apply for transfer.
Huh.
If they're coming out of jail, we try to do it while they're on their day they're coming out of jail so that we can then they can go immediately. So when those timelines get disrupted, other states ask questions and say,
Yeah.
don't let them come here, even though they're going to mom's house.
Hmm.
And we could theoretically send them there immediately while the investigation's pending.
I didn't know there was a timeline.
We have timelines
I can't
around
think,
transfer.
Mark, of any case where someone's been on furlough and then we're seeing them for parole that they've been recommended to go out of state.
we had one.
I've not had one, but most of them all come from the facility.
We had one. I don't remember who it was because I remember bouncing it off Lori. It was back a while ago. We had one and that's where that came up. So I just.
The big thing for me from management perspective is that we should, if we have a place in another state, we should be recommending at
Yeah.
a minimum. to
Well,
go
if it comes up during the
right.
hearing, a lot of times we'll ask the PO or the caseworker, is DOC looking into sending them to this state? Because it doesn't make sense for us to go down this road if that's what they ultimately need to do.
Yeah, I mean, the PO might have there's a lot of reasons why people see
Yeah.
it in that direction. For me, for everybody here in Central anyway, and most people in the field, we have more. Furlough's kind of a pain for us, frankly, because we get all of these rules from the legislature because of furlough, not because of the parole board.
Right.
So if I can send a person for you for a violation and you guys can make the decision independently from us as to whether it was a good violation or not, I'd rather do that, frankly. So if we make all the decisions on furlough violations,
Yeah.
and then we do the hearing on a furlough violation, and then the legislature says you're keeping too many people in jail. So,
Yeah.
and you're controlling the spigot. Now, coming out, we do a good job bringing people out, getting them in places where, moving forward. But I would rather have you guys make that decision too. But we still have furlough. POs have had a difficult time adjusting to
I know.
that
Yeah.
process, especially the older ones. The new people, you can teach them.
They don't know what happened.
They don't know.
The older guys
That's not the way
get a little rigid.
we always do it.
I can be that way sometimes too. So
No.
I've been around a little bit.
No. We never had
I
any
try.
debates. We never had any debates.
Mhm.
Okay.
Thank you.
No other questions. I'm gonna
Appreciate your time.
move out of here. No problem. Anytime you guys need something, yeah, I'm responsible for reviewing all the violations, returns and stuff. So if you're having an issue with like the furlough parole discussion, just let us know and we'll hash it out with the DMs.
Great.
So it's always good if we have specific examples though, so that
Yes.
Yeah.
we can address that specific office. So may not be a person it may not be an individual thing. It may be an office policy that we need to deal with. So
Or just a
or a
misunderstanding.
misunderstanding. Yeah.
Yep.
Yeah. People like control and
Mhm.
furlough's control and parole gives them a little anxiety, I think. So. All right.
Thanks,
Mark.
Mark.
Thank you.
Mark.
Thank you, Mark. Nice seeing you.
Thank you.
Lori, do you have anything?
No, if you don't have any questions, I can also get out of your hair. I want to make sure Mark answered what you
Yeah.
needed on that.
That was good,
Yeah,
having him here.
it was helpful.
Yes.
I think too, the lesson I'm getting recently is who we're communicating with to get our answer
Mhm.
at the end of the day. POs are doing their best in their case by case situation, but it may not be the same messaging and or process or procedure that comes out of Mark's camp at central office. So, I think you all know the disconnect there sometimes. So if we have questions, yeah, exactly.
Mhm.
Exactly. And they'll do the same arm wrestling with me, you know, the POs will reach out and start telling me, I'm like, here's your policy, here's what they're telling me. And then it's quiet after that. But yeah, so if there's questions that you have on what DOC really wants to do with a case and you're not comfortable or fully invested in what the PO is telling you, you can let me know and I can get you guys some information as well.
Sounds good.
Well, good. Well, we haven't had any new cases on the parole board front since the last time I saw you.
Everybody's swamped, I think.
A couple rumblings of stuff coming out, but I think we've nipped that in the bud when it comes up.
You have a new attorney?
We have a new attorney. Yep, John Lacey just joined us. He will be with Bob doing more. He's taking more of our civil cases over our injury cases. So we'll be switching John in for Brendan, I think, in the near future.
I think, I don't know, remember if it was Brendan or Bob who emailed us yesterday. John's going to be shadowing in September and starting to take on cases in October, I think, is
Yep.
what we
I
were
met him
told.
met him at a PC hearing
Yeah.
yesterday. Yeah.
He was a prosecutor out of Massachusetts for a number of years. He also worked, he was a defense attorney and he also did, basically hearing officer work in correctional facilities down in Massachusetts. So he comes to us with kind of baseline that's much stronger than we would normally see. So that's why he seems to be a good fit to transfer over to your cases. So hopefully, Bob's back from vacation this week and then should be around consistently now. So, yeah. And then we have, I don't know if you guys probably haven't seen her, but we also have another attorney, Kimberly, Kim Johnson. She will be on my side of things as far as any appeals that come out of your decision. She'll be helping debrief those. So I've kept her separate from all the violation stuff at this point. So I'll get her over to introduce to you guys too. Yeah, we have a full team.
Great.
First time in a long time.
Great.
So hopefully, but no, you guys have been doing great things. It's been pretty quiet and PRO hasn't beat me up too much about anything, so we're gonna take that mojo and move forward. Yeah, exactly. Yeah, and I think Attorney Martin, she'll be going out on leave again shortly, so they'll be short-staffed again.
I think they're figuring it out. There was talk of Don Matthews coming in to take on a few cases in her
Yeah, she might be.
absence.
Annie's trying to figure that out right now, so so they may be a little clunky going into the fall, but hopefully by Thanksgiving time, both teams will be settled. So apologize for that chaos. Yeah. Okay. Well, I'll get out of here.
Thank you, Lori.
Do your
Thanks, Lori.
business. Thank you, guys.
Thanks,
Have a
Thanks,
good
Lori.
Talk to you tomorrow.
Yes, ma'am.
Okay. Next up, we got our reconsideration request.
Yes, there's two of them. One is more recent than the other one. The first one came in recently. It's regarding Matthew Manning. Annie had sent in a request for reconsideration and Brendan had responded.
Mhm.
So I haven't done a lot of research in these. So I'm gonna,
Pretty sure I was in on that, but
I can tell you.
I was in on that, I believe.
Staff meeting.
So, Sam and Katie, have you had a chance to look at our reconsideration policy? So it's in chapter 18, basically, and there's a fair amount to it, but the substance of it is if we get a request for reconsideration, it's supposed to come within 30 days, which is one of the things we've been talking about changing. Sometimes we get things much later than that.
Will we still take them sometimes if it's
Yes,
later than that?
Yeah. So, and then when we bring them before a staff meeting, we review the case. And if a majority of the board agrees to the request, then we would redo the hearing. But essentially, the request needs to include some sort of documentation that there's something that is new that was not afforded the board at the time of the original hearing that might change how we made our decision, or something that was omitted or just wasn't part of that hearing.
Very similar to like cases that would come up for appeal and that sort of thing.
Yeah.
So in this case, Matthew Manning's parole was revoked. It looks like he had a pending DLS, DUI, and he also admitted, so he admitted to that pending that alleged condition 1 and condition 9, which is the no drugs condition. And the board was Pat, Dean, and Lynn.
Yeah, the findings right there.
Yeah, basically.
Do you remember, Lynn? He's sleeping.
The hearing happened on
No,
August
I'm
8th.
here. I remember. I was looking at, I was,
Okay.
Yep. So based on the testimony of the parole officer and the details of the pending charges which need to be resolved, it is the unanimous decision of the board to revoke Mr. Manning's parole.
and now they want a second look.
Yes. Sounds
Based
like they
on
want, it looks like they want to redo disposition based on,
Valley
So we can go to
Vista.
Valley Vista.
yeah. Because Annie's saying that due to the
What we didn't
difficulty,
know, right?
yeah. Basically, she was having a hard time coordinating a 3-way call because DOC's new policy requires that prior to resolution of a violation that the attorneys coordinate any treatment calls. DOC won't coordinate those calls.
How can they,
Is that something new?
yeah,
Yes, it's
that the
brand, it's new.
attorneys-
how can they? I don't get how DOC can dictate to prisoners' rights?
I don't.
Because it's setting up a time issue that's beyond comprehension.
Yeah.
Because prisoner rights is going to continue to, well, we couldn't, we couldn't. And DOC's, well, you didn't conform with our policy? Well, DOC is not prisoners' right. I don't know how they're dictating
Yeah.
policy, but I
I think
you notice
DOC.
I highlighted that because I saw that. I'm
Yeah, I
going,
think DOC is basically saying until the violation is
Resolved.
resolved, we are not gonna try to coordinate any treatment for the person because we want the board's decision on.
I understand the treatment, but it's the review or the attorneys rather than caseworkers coordinate, facilitate screening. It's the screening. I can see prisoner rights. Well, we can't get them in a screen. Another 30 days. They are booked up. They can't screen.
Well, and DOC is saying we want the board to make a determination before we're gonna even waste.
What are
take the
his
time to.
original offenses?
You think so?
Is a sex offender thing.
Well, the question I had when looking at this was, we didn't get notified by PRO that they were having him screened the day before the hearing.
I think it said,
Wasn't
they
this the
couldn't-
guy that never showed up? He'd had like 6 or 7 chances to go to Valley Vista and then he would never showed up. And then he's sitting there and PRO was like, oh, but we have an appointment on Monday. And it was like a Thursday. And we were like, no, rinse and repeat on this guy.
I just wondered what his.
No,
original
they actually had him
offenses were as
screened
far
the
as
day before,
drugs.
but didn't
Right.
tell us.
Okay.
So his original charges were aggravated domestic assault, methamphetamine possession ×2, DLS for DUI, leaving scene of crash, property damage, and a few violations of conditions of release are his current charges. I mean, if you want to listen to the audio, I can play it, or we can table it. And I just realized that I had these, so I just wanted to. The June one is the one that I really
I'm
like.
just wondering about the statement from Annie that she was unable to get him screened until the day before his hearing.
And she hadn't gotten the decision yet. She hadn't
Did we
gotten
know
the
that?
results. I believe so.
Okay.
And she had not gotten the results of the
So-
screening.
She'd gotten him in for the screening, but they hadn't received anything.
If I remember correctly, yes.
Okay.
and then she just received word that there's a bed on the 19th of August. My question would be, is that bed even still available, given that it's now the 27th? I mean, those
Well,
beds
that
go
would
quickly.
that would come up at that wouldn't be something that you take.
If we.
That would come up in
reconsider
a new hearing.
We would go down that road at the.
Yeah.
How long is Valley Vista?
Depends. They have 2.
14
Yeah,
or
a couple of
21
different
days, like
programs,
28
but
days.
Depends on the program.
The cheapy one is like a couple weeks. Yeah.
That's a question that could also be asked at the hearing. Like, what sort of program are they thinking for him?
I don't know that a 14-day program is going to do him any good. And I have a feeling he's done it before.
I mean, these are pretty significant charges.
if he
It's
shows
not-
up.
Yeah.
Well, the main issue for reconsideration, is there something new that?
The
we
new
didn't
information,
They're kind of,
not
yeah.
not the details of the. So
Yeah.
we don't hash out the details of the case. It's
Yeah.
more of,
Yeah.
does this warrant the new does this new information warrant enough to rehear the
So
case?
the information that he had, he was screened.
Is that he was screened
He
and
was
has a
screened and
bed?
has a bed.
Right.
I would say there is, based on that new information.
You want to listen to part of the hearing?
I'm against.
We can if he wants.
What'd you say, Lynn? I'm sorry.
I'm against. I don't think it warrants a new hearing.
I can play some of the hearing if you think that would help to make sure that.
Well,
that
it would
is
be
new
in the
information.
disposition part of the hearing.
Right, and I can, if you give me
Try
a
to
minute,
find
I
it,
can.
sure. I can't remember.
I can remember
Really
it.
can't remember.
I can't remember that specific.
Yeah, I'm shocked.
I can't remember everything that was said, but I remember being.
But I
at
mean,
that
they-
hearing.
Having a new hearing doesn't necessarily mean the outcome would
Oh,
change.
no, no,
No.
no, no.
So, but I think
No.
just
No.
based on the fact that there's new information, it meets the criteria
That's
to,
what we need to consider.
Yeah.
So that was,
days, and then now I'm moving away from there, and I'm out where it's not that.
Liz
At the
Vera
house.
had that one.
Hmm.
Liz
Lawn.
Vera,
Meaning with,
she was the PO.
We are asking that Mr. Manning be continued on parole with a reprimand and a requirement that he attend inpatient substance abuse treatment. Mr. Manning has been on, you've been out in the community for quite a while, right? How long have you been in the community?
Yeah,
Okay.
3 years, 5 years.
All right, and we did do an intake, a screening with Valley Vista yesterday over the phone.
Yeah.
They have not gotten back to us about whether they've accepted Matthew to the program. We tried to do the screening earlier in the week in the hopes that we would have a result by today, but there were issues with, now my office has to coordinate the screenings. There was an issue with trying to do a three-way call from my phone with the attorney line in the prison, and then dropping the call, and then the soonest that we could do it was yesterday afternoon. So we are still waiting to hear back from Valley Vista. But Matthew, you have gone through treatment before, right?
Mm-hmm.
And what do you think would be most helpful about treatment this time?
And then I stayed away from the drug that I was on the last time when I went in, and then I went I went to when I first moved up north, to North Troy. It was the grandkid that lived there was in the cocaine, and then I was doing it, and I seen him on it like day in, day out. And then I ended up relapsing and on that. I went to rehab for it, but then when I got back, he could right like my face. And then now I moved away from there, and I'm out where it's not that at the house. And then that, if I feel more grateful about not being that. I stayed 9 years clean in cocaine for 9 years and without using. And I feel that from where I'm at, I ain't got nothing around me, and I don't have means to get to it at this moment because I'm too far away from where I was working it. And no, I don't want to hang out with people I've been around, so I'm trying to stay away from where I'm now, at where I'm living now. I'm sorry, my speech, it's the way like, lots of relatives play. I am in the fire.
So he has been.
Yeah, so I think I know sometimes, so Mr. Manning he has partial paralysis, and so just to sort of emphasize, you were clean for 9 years. You had a 9-year period of sobriety, is that right?
From cocaine.
From cocaine.
Then I had that after I moved to North Troy with the grandkids that moved in the house. Then I went to rehab from there. I went back to there.
It's
So that was the bound thing for me to do because I did
back into
I'll
drugs.
be back into danger. And where I moved to now, there ain't nothing there. So I feel like
must be having Wi-Fi issues.
if they say where I'm at and not be down near people I was down when I got living down in town in North Troy. I feel safer, and I've lived all this life, I don't remember it's called living or whatever they got going around.
Sorry, everybody.
That's okay. That's,
I actually don't want to do nothing. I really want to stay clean now. Because I'm too many people dying to quit and scared, and my daughter's doing too much of it. I'm good with the drugs. I'm not. I honestly, I don't want no more because I'm afraid of doing something dying, and my daughter can't have that. I mean, I lost my father to alcohol, and I quit drinking since my dad drank himself to death. So I stopped drinking at that point. And now this whole thing, there was a person here that died in AT that he came in on that live team. They don't have nothing to put gas for it, nothing like that. So I'm good with it. I don't want no more. And I want to rehab, try to get Dave Clean find enough way to find out not to I didn't have an idea on the back of my block, and that helps with paying off and everything, because that did help me for quite a while.
Okay, good. So you're back on Suboxone right now. Good. And if after Valley Vista, it's recommended that you do other outpatient community treatment, is that something that you'd be willing and able to do?
Yes, I want to do that. I want to get back to Trevita. I've not been doing the Trevita groups. I want to get back into the Trevita, and I want to go in, I want to back my counselor up with human services up in Beverly, and I want to get back on where I was before I got just for cocaine. And I was going on a plane after that. I went up to North trying to get away from the crystal map because I was on that. And after I got up there, I feel that I've been good. I've been doing good to stay away from the crystal map. And then the cocaine got put in my face. But now with all the lives or whatever problem, or whatever, and I don't want those more. I'm too worried about dying over doing a little bit of cocaine or whatever. So, I mean, I stay away from when I heard that monster kill stuff was going on. And then I thought there and everything else, and then that's when I ended up staying here.
Can we get to Liz?
All right, thank you, Mr. Manning.
Oh,
Thank you.
If I could just add to that. So I have supervised Mr. Manning for at least a year. I just wanted to respond to some of the things he stated. He, as he just stated, is just trading one drug for another. So meth was a problem. Now it's cocaine. I believe at one point it was fentanyl. Mr. Manning's had plenty of opportunities, internal sanctions to attend treatment, to go to inpatient. He had gone, previously to inpatient, sporadically participated in counseling. This is a continued behavior for Mr. Manning. If the board does choose to release him to inpatient treatment, we would request that he goes to some type of sober living after that. Mr. Manning's housing has been severely unstable since he has come up to this area from the Hartford district. He has a camper that he's moved to numerous different properties, both of the previous landowners that he was living with. It's shared lots of drug activity, failure to come back at night. He continues to engage in criminal behavior. There was a time that he had police contact for very similar behavior of leaving the scene of an accident. No charges came with that. I'm just going to object to that because now we're going beyond violations that have actually been brought into things that we have not been given notice of.
Liz, if you just want to keep sort of speaking to prior intervention short of incarceration that you've tried with Mr. Manning that haven't been successful.
Sure. So Mr. Manning's had multiple opportunities to go to treatment previously, and he's chosen not to. He's been placed on GPS to try and mitigate his risk of engaging with individuals that are known drug users in our community. He mentioned that he would be in an area where drugs would not be an issue. It should be noted that he picked up these charges while he is living at this residence that he sounds like plans to go back to. That's all I have to say.
Liz, could you just confirm how long he has been on supervision without a return to the facility?
So Mr. Manning was granted parole in March of this year, specifically with the plan for him to go to North Carolina. He was placed on parole in March. The plan was for him to go to North Carolina. The only reason he met criteria for parole was because he was going to be ICOTSed out of the state. I then put him back in front of the parole board stating that he didn't end up going, and the parole board told me that that's not a reason to revoke his parole.
Right, but not just talking about parole, how long has he been on supervision in the community?
That's recent. I think he had a rescission hearing.
I would have to look in our system.
He came from another district.
I'm trying to look up his movement history now.
I am as well.
Thanks, MJ.
I think I beat them both.
Yeah. I wouldn't doubt it.
This is never.
History and tiny terms, trying to figure it out.
Oh, that was.
I like tiny term.
I have it open. If you give me 1 second to read it, I can tell you. It looks like he was placed on furlough on March 8th, 2021. And then he was transferred up to Newport PMP in February of 2023, is what I'm seeing.
That's what we're seeing as well. So he's been out in the community for 3 years without a return to the facility. This is his first time being back. He has been in for over 30 days now. And we do think that this has given him the reset that he needs to be able to get back out, successfully complete treatment, and achieve and maintain his sobriety in the community.
Jim, for a deliberative session.
We don't have that, do we?
No, I mean, I think you can deliberate in you can
Yeah.
motion to a deliberative session if you.
So, yeah.
Second.
Motion's made and seconded for us to enter a deliberative session. Those in favor signify by saying aye.
Aye.
Thank you.
Give me 1 second and I will open up a breakout room.
What are these?
Bacon and scallion and veg.
Okay, this is the bacon and
You
scallion.
can see and hear the room now, if you can hear us.
You want to know why? It's because I left and came back.
All right. But yes, I can see everybody and I can hear you.
It's because what happened is I plugged the computer in to use Yowling to broadcast instead of using my own Teams, and I think that's what screwed it all up.
Gotcha.
So I can fix it.
Oh,
So the next one, I'll do it something different. So
Is Lynn there?
yes, we are all back.
She looks like she has a slash there.
No, she's back.
She's here.
She just didn't have her camera on.
Oh, okay. Can you hear us? Can you talk?
Can you hear me?
Oh, yes.
Yes.
All right. So we're back in regular session and have had a chance to discuss the request for reconsideration for disposition only in the Manning case. Would someone like to make a motion?
I'll make a motion that we have a reconsideration hearing for Matthew Manning.
I'll second.
Motion has been made and seconded to grant reconsideration of disposition in the Matthew Manning case. Any further discussion?
We may have to go around the room.
Cutter with that.
I don't know if we'll be able to hear people's eyes or
Okay.
names.
Red shine, sharps.
Hearing no discussion, those in favor of the motion, please raise your hands.
Okay, never mind.
Those opposed? We are
Okay,
6 in favor and 1 opposed.
okay.
Thank you.
I thought it was gonna be a lot more.
That's from my old selectman days when we didn't have.
I know, but I just thought it would be,
Get on the board.
because I didn't know how it was
Okay.
gonna be. I had to take a
Okay,
phone
the
call.
second case is
Scott Allen, and I,
Scott Allen.
so this one is old, and it is without, so Dawn,
This actually works better.
so this one got lost in my email, and I apologize to Dawn. She sent it in on June 5th. I have to look to see when his hearing was. That's why you're getting it so late. His hearing was on, his hearing was on June 11th. She had sent the reconsideration on June 19th. So it was timely. Brendan responded. And there was some back and forth between Brendan and Dawn, starting on page 3. So the original request is on page 4 and 5.
Oh, we have any page numbers.
I know. I'm just, okay, so the email dated Wednesday, June 19th at 12:41, Don Siebert wrote, I write to ask the board to reconsider its decision revoking Mr. Allen's parole. Mr. Allen had requested a continuance to obtain records from his psychiatric hospitalization in April of 2024. I have attached those records. They demonstrated that he was, I don't want to go into all the details. So it demonstrated that he was admitted into the hospital. There was a period when he was unable to complete a sufficient amount of work to avoid termination from the program at Claire Martin. Mr. Allen is willing to engage in sex offender program. He asked the board to reverse its decision, revoking his parole and release him to the requirement that he re-enroll into Claire Martin. So then Brendan responded on Wednesday, June 19th at 1:18. And that is above, if
Yep.
you all would like to
Yep.
read that. And if we do need to listen to the audio, Carla and, not Carla, Colby and Lynn, I will join the hearing on my own computer to try to avoid what just happened.
I wasn't involved in this when I don't remember it anyway. I think it'd be
It
good
was-
to listen.
It was Dean, Pat, and
I
Sam.
was.
I think I
It was
observed.
back on June 11th, so it was back a while ago.
Yeah, I'm pretty sure I observed this one too.
I don't remember this
So it's
one.
Sam's fault then?
It's Sam's fault.
I support that.
I can take the fall. I was real pregnant. I'll blame it on that.
So if you'd like, just let me know and I will.
I mean, for me, just reading it, I don't see new information, but maybe I'm missing something.
I'm reading information that might have been not heard, but he failed to
Say it.
say on his own that he could have.
Yeah, the records that she's referring to are what we didn't
Right.
discuss.
Right.
Is that gonna make a difference?
Good question.
I don't
Would you
know.
like me to play it?
I would.
Okay.
I don't want a whole one. That's the only thing.
Here, you want to have one? I can have
What kind do you have?
Everything.
everything, like everything, okay?
Do you not want your other hat? I'll eat your other.
The sweet one. Look, I think this is a wheat one.
Just give me 1 second. I'm queuing it up.
Dean, do you want a bagel?
Well, I might look and see what you got. You smell pretty good.
I saw you looking.
Yeah, I know. It's hoarding everything down.
Horrible.
Okay, so he didn't.
Ram, you want a bagel?
Jim, is that the veggie that you have right there?
No, I think this is. I'm glad you didn't bring bagels last month when I wasn't here.
You did.
That's the
You offered
veggie.
me
He
the
just
donut.
brings flavored cream cheese. So
Here's
so those of us who do not like flavored cream cheese don't get
No, I
bagels.
knew there'd be a.
Here's the knife that goes in
I
there.
knew there'd
I think I'm okay for now. I might have one a little.
He didn't bring bagels last month.
I know, I said, I'm glad you
Oh,
didn't.
yeah.
Why don't you get something with like veggie? I prefer that.
I prefer cinnamon and raisin,
Yeah.
but plain's good
The
too.
bagel?
Yeah.
They're in
There's
there.
only one
There's
chunk
13
I had in
bagels
there.
that are mixed. Either that or I
Alright.
got it.
Should
So
be.
it's- I'm not-
Wayne, you're so underappreciated for
Today's
this.
date is
know.
June 11, 2024, and we are doing Rutland probation parole hearings via Microsoft. I will say that the bagels were very good last month. I did take some home and put my own cream cheese on them.
Put your own cream cheese
They
on.
do smell good.
Well, I'll never make this.
Do you want
It's all
veggie?
good.
Not really.
Do you want bacon and
scallion?
Yeah, that sounds good.
Yeah, I could do the bacon. That's a scallion that
Yeah.
You can pick the little green stuff
I
up.
complaints, you know.
I do eat cream cheese with green stuff in it just about every day when I go to the bagel shop. It's just olives.
Oh, I love it with olives.
Oh, I almost.
Do you admit or deny violating that?
That he
Is this from
feels
up in
that
the
he should
islands?
receive credit for.
Okay.
Unfortunately, the department doesn't recognize.
Pretty
Wow.
for convictions.
Actions recommendation, please.
Go ahead, Cody.
Okay. So as far as my recommendation, I am recommendation revocation of parole.
Yeah, and I would, just emphasize, Mr. Allen is on supervision for convictions of sexual assault with a minor and lewd and lascivious conduct with a child. Obviously, these are extremely serious offenses, and the need to complete sex offender treatment is really important, and I think is really a pretty minimal way to demonstrate, that Mr. Allen understands the seriousness of his offense and the importance of not having similar behavior again in the future. So it's very concerning to have him removed from the group. And I guess, Cody, I would just ask, in your supervision of Mr. Allen, has he expressed any reluctance to attend treatment?
In the beginning, there was a little hesitance to Scott wanting to participate in group. He was part of a group here prior to becoming incarcerated that he feels that he should receive credit for. Unfortunately, the department doesn't recognize that group anymore. So the new Claire Martin Center is where we refer all of our sex offenders to, and is
I'm on the internet.
sole place that we do sex offender treatment.
Okay. And so he felt basically he should have got.
Yeah.
Come on. You can do it.
Credit for prior programming.
Correct. Yeah, he felt that he had, satisfied that condition through that group.
And was he, before he was terminated from this program at the Claire Martin Center, was he placed on a probationary status?
Yeah, he was placed on probationary status. Let me just look at my notes here. In February of this year, they continued him on that probationary status for about almost 3 months before he was terminated for continued behavior.
And did you ever speak with him after he was placed on probationary status about that status and the importance of completing programming?
We did, myself and the team, we had a couple interventions with Scott explaining the seriousness of the matter and, you know, what we were looking from Scott from that point forward to continue into group and to get himself off from probationary status in group.
Okay. I don't have any further questions for Cody.
I just have clarification from Cody. You mentioned that Mr. Allen was in a group previously in the community. Are you referring to the group run by Kimberly Ryder?
Actually, I believe it was a group that was actually ran by a couple of our probation officers. I'd have to get the names of those officers that were running the group, but it was in the time that we didn't have a provider, so we were doing something in office to help alleviate that.
Would that have been maybe Matt Christian and Nick Daigle, that group?
I believe so, yes.
Okay, and Mr. Allen was in that group when it was running?
He was in that group for some time, yes. I'm not sure how long or... But he was actually...
sorry.
No, he was in that group at some point, yes.
Okay. And there was actually... He attended some programming even before the group that was run by Matt and Nick here at the PMP office. Are you aware of that?
Are you referencing Ryder's group?
Yes.
Yes, I do believe so.
Okay, and at that time, that was the DOC approved group, right?
At that time, yes.
Okay. All right, so we're asking the board to continue Mr. Allen on parole or in the alternative, continued disposition to allow us to present more information about what's been happening with Mr. Allen over the past few months and a plan moving forward. Mr. Allen was in treatment, both with Kimberly Ryder when that was the approved group, and then in the group at the PMP office. He has struggled with the Clara Martin group. He is completely willing to do treatment. He's going to talk to you about some of the struggles with someone of his age, with remote, like a video counseling, and some of the struggles with the technology that he had. He's absolutely willing to do sex offender treatment. He did the full program while he was incarcerated, Vitipsa up at St. Albans. He was in the Kim Ryder group. He was in the PNP group. And he has stumbled with Clara Martin, in part because of the format of the group, and in part because his mental health issues have been very prominent in 2024. And he's going to talk to you about the kind of the emotional roller coaster he's been on with the death of his sister and a close friend. He did spend some time, he checked himself into the Rutland Regional Medical Center in the past month or two. He did a voluntary commitment. And he is currently seeing Kim Ryder for mental health counseling. And I spoke with Ms. Ryder. It's not clear to me. She does run a sex offender group for the federal probation office. And it's not clear to me, given Mr. Allen's condition, whether he could continue doing sex offender counseling with Ms. Ryder. She is willing to take him into her group, but I would need more time to figure out what that would look like. And I'm not sure DOC's position on that. He's also willing to re-enter Clara Martin if they would take him back. So I'm gonna ask Mr. Allen a few questions, and again, what we would like the board to consider is either continuing him with a requirement that he get into treatment that's appropriate, either with Ms. Ryder or someone else, or give us more time to present more information about his mental health struggles. He does have an appointment with a psychiatrist at Behavioral Health on June 20th. He'd been attempting to make that appointment for a while, and I'm hopeful that that's going to yield some better mental health care that will allow Mr. Allen to be more functional. So let me ask you a few questions, Mr. Allen.
Sure.
So you've been out on furlough and then parole since July 2022, right?
Right.
Okay. And when you first came out, who were you seeing for sex offender treatment?
I was seeing Kimberly Ryder.
And how was
Can I
that?
stop this for a second?
Yeah.
Because I think the new information
It's just the,
is the
Psychiatric.
the actual dates, which she did bring it up during the hearing.
Yes,
So I just
yes.
I figured I'd save us
Yep.
some pausing and stuff. So because that seems to be the only new information was those dates that came up.
right. She reiterated in the hearing that he would be willing to go back to Clara Martin.
Yes,
If they take them.
Right.
but he wasn't willing to do it before.
Right.
Right, well, he didn't want to.
Right.
He only wanted to see that one therapist. He was only willing to see that one.
I vote no.
I vote no.
Well, we don't have a motion.
I'll make a motion.
We're discussing right now.
Okay. When you want a motion, let me know.
Anyone else? Any thoughts?
I don't see anything new.
Are we in deliberative session?
No, we are not.
Oh, we are? Oh, I thought we still were. Sorry.
No, because we're reviewing the details of
okay.
it. We're not in.
I'll make a motion
We're
to
not
go into
deliberative.
deliberative session.
Okay.
I'll second.
All those in favor of entering deliberative session for this case signify by saying aye.
Aye.
Lynn?
Aye.
Unanimous. We shall return shortly. For whoever can.
We'll be right back.
Can you hear us and see us?
Can only see, I can't hear you.
I
Well,
can
I
hear and
can
see
now.
you.
They're both talking.
Yeah, I know.
All right, we're good.
Hold on.
Yeah. It's.
Is that still happening?
Wait,
There you go.
that's
Yeah,
Oh.
great.
The Outlink does not like breakout rooms.
Okay, so we are back in regular session. We have had a chance to review the request to reconsider. Is it Scott Allen?
Yes.
Scott Allen's revocation of parole. And I would entertain a motion.
I'll make a motion that we not have a reconsideration hearing for Scott Allen. We reject the
Okay,
request.
based on that
There's not new information. Is
Okay.
motion has been made and seconded to deny the request for reconsideration from Mr. Allen. After the board has reviewed the request to consider it, we find that there is no additional new information that would have likely resulted in a different decision. All those in favor signify by saying aye. Aye.
Aye.
Thank you. Got it. All right. Thanks, everybody. Updating the manual.
Yes. So I had hoped to have like the manual in the new format for everybody, but as I was doing it, as I have it all in the new format to the new table of contents. But as I did that, I thought it would confuse everybody because I think we should go through the new chapters, chapter by chapter, and then do it all at once. Put it all together at once at the end. And then because there's so many changes that need to happen throughout the manual.
Yeah.
So what I have here today is chapter 1 that I wanted to bring before the board. And I can go through it a little bit.
Okay.
So this is the new general provisions chapter. So the first one is the definitions section, and I didn't page number anything. I apologize again. And the formatting, it will not look like this when we're done. This is just the quick formatting. This is a very rough draft. So the definitions did not change. I didn't change any of the definitions.
Okay.
So that's just subchapter 1.
You didn't add anything new to it, right?
No.
The stuff that's new is underlined?
The stuff that's new is,
Yep.
so any changes are highlighted in yellow.
Yep, I figured.
The new things are underlined and the old things are crossed out, except for the first one, the executive order. I forgot to cross out the old one. It was from, I think, 03. We have since had new code of ethics from executive order of April of 22.
Okay.
And I verified that with the governor's office. That's the only thing I changed in here. I did not go through the ethics yet. That is in 4 of 22. I am going to go through that a little bit more just to make sure there's anything. But this is more the board that you're meeting this executive order, plus you have your own code of ethics on top of it. So I did not make any changes.
Well, this basically comes from the governor's office.
Yes. Yep. So then subchapter 3, policy and procedures development. A few changes I made on procedure. I changed a will to shall because the most of the manual uses shall and not will. And then I added that the parole board manual shall be placed on the board's website, and so that way it's not just made for distribution. We're putting it on our website basically as the easy distribution. And then E, I reviewed all of this because it says a review of policies and procedures shall be scheduled annually by the board chair. I don't know if do we want to keep it? We're going to do this annually because I don't know if we've actually.
Well, when we first adopted the rules, we scheduled an annual meeting to review any changes, but we've since gotten away from that.
I know.
Yeah.
And the question I have is, because we've gotten away from it, do we want to take the word annually out? I think it would be good that we try to schedule these more often.
But just in case it doesn't happen.
Right.
As corrected.
Yeah.
That fit?
A review of policies and procedures shall be scheduled by the board chair as changes occur or as revisions. Yeah.
Yeah. From time to time.
Okay.
So put it in place of annually as
Yep.
corrected.
Yep.
Once in a while.
Once in a while.
And then
Comes an issue.
subsection II, development of maintenance of crime severity index. I recommend taking this out completely. We don't have our own risk assessment.
No.
Plus, this was something that we were using DOC's crime index. So
Yeah,
I would suggest taking that out. Pardons I didn't change. And then I forgot subchapter 5 above victim notification and participation. I did not make any changes to that.
Roll packet. I like what you did. Summary. That makes a lot of it.
So then subchapter 6, access to information. In the first section, I suggested taking out Department of Corrections parole consideration report and calling it just parole summary report.
Yep.
And then changing parole packet to parole summary.
So
good.
And then one thing that I didn't highlight was F. That I did cross out. The offender shall be allowed access to their pre-sentence investigation report if included in the parole packet at least 7 days before the proceedings. We haven't been getting PSIs so I just suggested we just take it out.
do they get
We used to get them
anymore?
once in a while.
They just don't do them anymore?
They do them, but they're a confidential document that I don't think get distributed very often. So I just didn't. I don't know if we leave it in case we get one, or because we don't require them to submit a PSI.
I don't remember ever seeing a PSI in a
Case staffing is what's important. Yeah.
Right.
Yeah.
So that's why I'm asking. I'm
Yeah.
suggesting we take that
I
section out.
agree.
I don't,
Back on the
Yep.
section A,
Yep.
do we want to include any of the documentation that we require using the SDMF?
Yes, that needs to be updated. I didn't update that, so I'll make a note to update for SDMF and bring it back to you all.
Dave LaJoy.
Dave LaJoy.
Okay,
Sorry.
the names,
It just hit me.
David LaJoy. yeah.
It just
okay, the
hit me.
name's familiar.
Oh, yeah.
I think, yep.
The Joyce. I don't know why it just hit me.
It'll happen.
It's worse. It's worse.
And I also think that we don't need to make a decision on this today, but I think it's good just to
No,
good to show it, and that we can also come back with, because I've got some edits to make, and then we can come back next month. Maybe not next month because Richard's here, but in October and go it down a little
What
bit
you done
more.
is fine with me, have a.
And I'll try to have September. I'll have the next chapter to you all now that I've got it kind of formatted. It's just been absolutely crazy. To you all, and hopefully by October 1st, so that you'll have time to review that prior to the October meeting.
should we include under board subpoenas? Under A, the statement that the board may issue subpoenas as it relates to confrontation of witnesses. In addition to that,
Are you talking, so you're talking just an A?
yeah, well, I'm just looking at it. It says, as the board may find it necessary for investigation, but the reality is
We wouldn't do it if it
it's
wasn't
confrontation of witnesses that is requested by the Prisoners' Rights Office.
As it may consider,
Necessary for what's in.
yeah, board may issue subpoenas, compel the attendance. As it may. What if it's, and this might be something to run by, to conform to the rules of evidence and confrontation, or
So I was thinking at the end of that sentence, just comma, or when confrontation of witnesses is not waived, defense attorney.
okay, but we never
Just-
know. We never know if it's waived
Yeah,
anymore.
I know.
Okay, let me.
Something to that effect, whatever.
Do we still have district courts?
I think so.
I don't believe so.
No, we do not. Thank you for catching that.
We don't have district courts.
They don't call them district courts, and what do they call them?
Superior courts.
They're all superior courts,
that's
criminal
right.
division.
That's right.
Really?
That's right.
So you might want to change that.
Good point.
Good
Where
catch,
is
good
it?
catch.
It's in the subpoena thing.
Yeah.
Subpoenas issued by the state's
Got it.
district courts,
I
has
still-
power and effect of them.
Oh,
I still call them district courts.
Didn't realize we didn't have district courts anymore.
oh, there it is.
Yeah.
I'm sorry. B.
I was looking and looking. Yeah, I didn't do a thorough, I will admit that I didn't do a thorough read of all of these. What if we, instead of put states district courts, we just put the Vermont judiciary?
That would cover.
Yep. I would.
And we don't have to worry about what they decide to title their name.
Is that a new A under 4?
No, sorry, that, I don't have my notes. I was gonna pull it up. So I had a question about this A.
Mm-hmm.
So it says no proceeding shall be conducted unless 7 days before the offender is scheduled to be seen by the board. The DOC provides the offender with the documentation that is submitted to the parole board. So the only parole hearings that you ask about the 7 days is, the only hearings you ask about the 7 days is parole hearings. Is this meant just for parole hearings? Because if you read this, it's no proceedings.
Right.
So should they be getting, should we also be asking for all other hearings? Are they getting a copy of their?
I don't know
reports?
if the other hearings are covered by statute.
I don't know, but I'm just saying this pigeons you to all hearings.
Also, how many times has the offender received his notification of the paperwork, like at the hearing? So with this, when you read this, it would be, okay, he didn't have it 7 days before.
Yeah, but the offender may waive the 7-day notice either in writing or on the record. That's
Yeah.
B.
We always ask.
Yeah.
I guess I'd like to go back and look at the statute.
I'm going.
Yeah.
Hold on.
There may be a court case too.
Yeah, we might have to do a little bit more digging on this
Yeah.
one, but I just
Yeah.
wanted to spark if anybody had any memory of, because it always comes up with parole cases, because I know it's huge with violations that they have to know what they're being charged with. And that's why we put in extra, because they weren't even getting their violations.
Right.
Is that a statute too, or?
No, but I think that's a due process, right?
Yeah.
You may have a problem with number 2 under the
See?
4,
Or
B2.
an exact confession. So.
B2 or C2?
I guess that's a Lori argument.
What? Which one?
Why did it the statutes?
The court, okay, so there's something in the probation. This is around PSIs.
Mm-hmm.
So I think that one you're talking about, Wayne, around the confidentiality,
Mm-hmm.
it comes up in the PSI statute and says the statute covers it.
Well, I think the Constitution covers it as far as confrontation. Period. I understand the PSI and I'm
just saying
I'd
the
have to do a
confidential.
little more research on that because I've participated in PSIs myself and have heard testimony from POs in open court regarding their PSI investigation. So a little wishy-washy on how confidential it truly is.
Yeah, and what part?
But this information shall be obtained confidentially. That's just flagrant violation of any constitution or criminal procedure. It promotes people to make stuff up.
I'll put a note to talk to Lori about it.
Yeah, have Lori take a look at it. I say it's going to be her argument down the road when prisoners' rights confronts that. I mean, when a PO says, "I was told that Joe Blow was having sexual relations with so and so," well, who told you? Well, it's confidential. No, no. That does not lie in the
Some of
United
the
States.
citations need to be changed to when I gotta go through and look at the citations.
In-camera
Because
review.
since presumptive's been put into place and stuff, it's changed citation.
Yeah.
So I'll
Okay.
check on that and see if it's in statute.
Okay.
Compensation.
And there'd be no reason not to have it for every hearing.
Yeah, I just think it'd be good process.
Yeah.
A good procedure for them and really to direct DOC staff to make sure they're giving copies of stuff.
Well, that completes chapter 1.
Yeah.
Couldn't take a while.
Yeah, it's gonna take a while.
What's that?
I said you're losing your free time, MJ, to go through these.
Yeah, my last week of the month, hopefully.
Should we hang on to this and,
I'll give you a new one next time
okay.
with the changes. I actually might skip ahead to chapter 3 some into the violations for next month when we meet with Richard. So we may do a little skipping around just because we've got Richard coming. But we'll get there little by little.
Yep. That's good. Okay. Structured decision-making.
Okay, I've been terrible about this. Thanks, Lloyd.
Sounds like a
for telling
confession
me.
coming.
I've been just coming out to say it.
We know.
From underneath
I'm just saying, I've been terrible about it.
And we've kind of not been bothering you as much because you've been on
What do you mean
maternity
it's so
leave.
terrible?
I just haven't,
It's
like,
because you're the new mother, they haven't been bothering you much.
see, I'm protected.
See, I thought it was a typo. I thought there was,
Oh, no, it's me. It is
What
100%
have you been
me.
doing?
Wait,
Nothing.
new mother, you can get.
Oh, you haven't
That's
been
what I'm
doing
saying.
that?
No, I didn't. Well, okay, I did a
You
couple.
get highlighted.
I did a couple.
You're actually in 2 of the ones that we're reviewing today.
Because I'm probably the one that's off, way off.
No, don't. I always say that too. We have our own minds.
I'll get better. I
did-
promise.
Yeah. Not allowed to.
no worries.
Listen, you're the one that brought this up this morning, so I figured I'd just get ahead of it.
So aside from Sam, how's it going?
I think it's going well. It's time consuming, but it makes you think.
Yeah.
It focuses you.
I think so. Do some case reviews.
Sure. Can we skip around?
I know.
How's the slide?
Where would you like us to go?
I want to go to the new parole summary. I didn't print
Yep.
one off.
Okay.
I think most of you have come across the new parole summary.
Yes.
If you were on hearings last week. We do have some data challenges. We do have some areas. It is in a little bit of a different format because we took the self-reporting sections out, which were around offender change, release plan, and ability to control behavior. And now they're in a questionnaire that the person really makes the person put some initiative into things. So they may or may not fill it out. And if they don't fill it out, that's going to show you how much initiative they have to get
Right.
out.
Exactly.
The affidavits are now at the end instead of at the beginning.
Which is good. You don't have to open them up.
Yes.
Right.
I I know, Wayne, you brought up a topic around the estimated release date up at the, so underneath the min and the max, it's always been on the parole summary. It's been titled, it was projected minimum release date if earning good time. This is a field that DOC's tried to put in their offender management system. It is a very volatile field. I would ignore that field. That was more for the office if they were pre-min to use so we could estimate about how early their hearing was if they were earning good time. So that field isn't really, it's very rarely accurate, and I've got to work on with the team. So don't put a lot of your time into that field. And we lost Lynn. I just realized.
Oh.
So really the minimum is they're eligible for release once they hit their minimum.
I was looking at the differences between early release and earned good time release. One of them heard was my calculation of.
You can't go.
That was St. J, but my calculation of what I saw on the thing was he was out 3/12, 11/3/26. So you back that up 6 months, it's 5/3/26. In the good time estimate, it's got to be a typo, whatever. He's got 6/16/24.
Do you have an example?
Heard.
ERD or
HURD.
UR or ER?
HURD. But
the other one about Sanborn.
Can we slow down, please? You guys always go so fast and then change
direction.
Yeah, you're notorious. Okay, so the projected earliest release date if earning good time was 6/16/2024.
Mm-hmm.
And then his minimum release date was 8/1/2024.
What's the problem?
So the projected is if they got all of their good time.
You can't.
So I'm gonna guess at some point he probably didn't earn his good time.
I picked up a DR. I picked up DR, whatever. You can't go by that because there's so many variables.
What is his minimum?
8/1/2024.
And what was the good time?
6/16/2024.
So you get out 2 months before?
He could be being that he's at NECC, he could be work camp.
Right.
So here's the question.
Whatever.
Is this field helpful? Because if we're going to sit and do calculations, is it really helpful?
I don't look at it.
It's more of a field for us for scheduling than it is.
I don't pay any attention to it.
I don't.
I'm just asking. If it's not helpful, I could possibly have him take it off if it's going to throw more confusion.
The only thing that's helpful is if you have somebody who may not be supported for parole, but has a max date coming up in a short time. And
so that
it's a little discussion.
So that date doesn't drive the max date.
Right.
Look, I always look more at the max than I do the
So realistically, in this case, he was already past his minimum.
Yeah.
So it didn't matter. So whatever date is in their system is just a static date that was calculated originally when he was sentenced. And I don't know when exactly he was sentenced. The only time it really could potentially mean something is if they're pre-min. So I guess, is it enough of a hang up because it helps Carla and Colby for scheduling.
Where am I supposed to do?
I just figure if they're on there, we're going to deal with it.
Right.
Yeah. You don't need to.
I had it turned off. Why isn't it doing it?
I don't know.
Is there anything else? Any questions?
I know what the minutes.
The one thing I did like that I was able to get from DOC on this is the narrative of the last two DRs. So I don't know if that's helpful to actually know what the last two DRs were instead of just seeing what the title was.
Right.
You can actually see what the behavior was a little bit.
So for me, it was super helpful last week when we did Northern State, when he had two DRs for misuse of his meds, and that he struggled with that anyway. And he wanted to get out and just said, his plan to stay sober is the first time he thought he was going to use, he just wasn't going to. Well, if you're doing it inside, trying to sell it and stuff like that. So that, I found it helpful last week.
So by doing it this way, we're able to pull a little bit more information from the system. So I just thought I would just.
There's also the SDMF domain of institutional behavior.
Yep. You're
You
not
see
just,
quickly by the dates how recent it was.
yeah, and you're not just looking at the list of everything,
Right.
trying to.
Right.
Okay. So that's why I wanted to just go to that first. But if you are seeing anything that looks crazy or funky on a report, let me know, because we're still working out there are glitches always. So I just met with the OMS team yesterday. Mark Devins and I are the point people for this. So we are bouncing back and forth all the time.
Good.
Yeah.
Well, I'll beat my dead horse.
I look at
The
it
criminal
and then I just don't
histories,
complete it, and then we do the
they're a
hearings
lot,
from the
they're a lot
next
better,
round
but
of them.
I really would like to see charges / convictions, and I'd also like to see failure to appears and violations of conditions of release, which I haven't seen on any of the new forms. They've been numerous. Some of them go right with the baseball scores that I saw. Then some only list convictions, and I haven't seen failure to appears or VCRs on any of the write-ups.
And quite a few still have no.
I mean, we still can go back and ask, but if they're putting half the information in, they ought to put the whole loaf.
For the ones that do, it saves them having to regurgitate it.
If they put them on the thing, then you don't have to ask them to go find it.
Want to do Mr. Pepin first?
Sure. All right. George Steen and there's Katie and Tom's.
What? I protest. I thought I was gonna slide this week.
You did not. If you notice, I did all the cases this month.
Yes, I did notice. I
So single. To George Pepin, it looks like criminal and parole history.
This isn't mine.
Did Tom keep yours?
That's sort of the Pepin Aiken. Yes.
So you don't know where they are on here, correct?
Yeah, I do know where they. It's
What I said.
it's on the first page and it's GP.
Gotcha. 1, 2, 3. That's one down.
I got it.
So it was criminal and parole history. It had neutral by Dean, aggravating by Katie, and mitigating by Tom.
Obviously wrong.
I said aggravating because he had 9 misdemeanor convictions and 5 violations of conditions. That's why I said aggravating.
And you found that mitigating.
No, I found that aggravating.
Oh,
I said 1982. That was so long ago. $50 fine.
Yeah.
I said, but that was small potatoes and the big.
I did. I thought, there was pretty limited criminal history compared to what we normally
I
get.
almost put neutral, but I said,
DUIs and LSA was mostly motor vehicle.
I did too, but I wavered. I wavered on that when I did it. I said,
So I guess so I think the biggest thing I'm looking at Dean's coding guide because I don't have one up. I think the biggest thing in this is looking at the escalation of severity and is there long intervals between the crimes? That's neutral. Mitigating is no criminal history or minor crimes with no escalation of severity or long intervals between crimes.
No criminal history since 1982.
So then aggravating is the extent to which the individual has early onset multiple crimes with short intervals between and crimes that escalate in seriousness, multiple breaches.
I think I saw the violations of conditions as being that, but I didn't even think about how the length of time, which I get caught up on sometimes.
I was wavering between both of them, and I kind of waved to the mitigating one.
I should have gone neutral. I think now looking back on it.
I don't like that neutral.
Well, it's good to review them.
Yeah.
I finished stuff in my mitigating.
Well, that one was easy. We had notes to go by. All right,
That's
Kenneth,
the only act, that's the only
no, that's the
domain.
only one.
That's the only one with me? I
I don't know if it's the only one with
Oh, hold
you.
on, there may be more.
I feel vindicated.
No,
I feel
No, they're not.
vindicated.
They're all me.
Oh, good, okay. Somebody else get it.
So we have
Me.
Kenneth, Cameron, Pat, Sam, and Wayne.
Aha.
Here we go.
And that one is Casey on the first page.
Sam.
Please.
I just don't like to publish these with all
Yeah,
the
that's
full
okay.
names.
No, that's all right.
And it looks like institutional community behavior.
Ah,
I have a mitigating from Pat, an aggravating from Wayne, and a neutral from Sam. So Sam, I would say I wouldn't point at you being in the middle, neutral weekend.
All right, I'm just gonna go neutral for the rest of the time.
No, I will say,
I noticed a
will-
pattern in yours.
I will start haggling you for notes eventually.
I will get better, I promise.
I guess I put mitigating because he's incarcerated and he hasn't received any DRs while he's been incarcerated. And to me, that was mitigating.
Yeah.
No disciplinary reports plus meritorious conduct, behavior that,
did he get any
maybe
meritorious?
shit,
conduct?
should be neutral.
Why? I guess he's meritorious.
I believe it's aggravating.
Why?
Why?
Yeah, why?
Because he was returned to the facility for refusing a drug test. He missed his appointments. He's had no DRs. And he was and he's got pending charges. Well,
This
he
is
was
the
in
guy that doesn't
community.
put anything down.
But he's incarcerated, so we consider while he's
History.
incarcerated,
This
not.
is all historical.
It's so, wait a minute, it's institutional and community
You
behavior.
have to read the sentences.
When coding this domain, you will use their current custody status.
Right.
His current custody status is incarcerated.
Okay.
It says, well, in the community.
He's not in the community. This is,
But you can use his, well,
okay,
Yeah, no,
I only, when they're incarcerated, I use their incarcerative
I do too.
status.
Yeah.
Well, you should be looking, so it depends on how long they've been
Exactly.
incarcerated.
Well, that's what I was thinking because
right.
I gotta
when I
find,
look at that, it's
recent.
only.
well, I
it's
gotta find
been
my,
less than 3 months.
If they
So-
just came in, I will use their,
Yeah.
if they've been there for a while, I'll use,
oh, where did I put that?
I don't wait.
I mean, he hadn't been in,
Just what I
by
did.
looking at this, he
I
hasn't.
agree.
I
Reading
used
my
both of
whole-
them. And I made them aggravated.
I spent a bunch of time they've been in the facility.
How long's he been in?
3, but it looks like, well, 4/9, and then this was dated 7/24. So
In 3 months, he's been good while he's been incarcerated. I gave him,
Yeah, he had
it
no
should have been
DRs.
neutral,
In that
not,
case,
Yeah.
you should stay in jail longer. then,
yeah,
right?
neutral would have been fine. 'Cause
Yes.
He didn't have any meritorious
right,
stuff, but
yeah,
he did have no DRs.
yes, it should have been neutral. But it should not have been aggravating.
Well, I still say it's aggravated.
You
to be honest,
Yeah,
to be
pending
honest,
all
I
the
probably
DRs
would have used the recent conduct from the community
And then he's
too and gone
refused his
aggravated.
test. He's in for possession of stolen property. These are new charges and new refusals and new violations
just-
while he was on furlough.
But
I just want to,
back
if
to
I
the
can,
facility.
interject and remind you that in our training, we were instructed to use only the most recent behavior, be it institutional or community.
I'm trying to find,
And they
Community
did not
release
distinguish by how
history.
much that meant.
Well,
I mean, that's an
we-
interpretation that we made.
we did have some of those discussions and I'm trying to find it and I'm not having good
Well,
luck.
say he just came in for like last 15 days, what would you use? Last 15 days or his last 6 months?
That's where you got to make the
There you go.
interpretation.
Community
So he followed
release,
his theory then.
community release history. This admission effective sentence.
It also says institution, community /
But, but you,
That's what I looked at it that way, and I'm looking at this guy, he's a total failure.
but you could say this admission, but there's also a slash that says effective sentence. So is it while these charges are still going on, while he's being sentenced for these current charges?
Oh, he gained these new charges and
Right.
refusing drug tests during his
Slow down and let
effective
me pull up
sentence.
that.
So I think if we look at the effective sentence,
Okay.
we could use the community behavior.
Can we take a breath?
Yeah.
And if-
Well,
Breath
while you're
and
doing
let
that,
us pull
let
up
us
some
just,
paperwork.
let's just hash this out while she's looking that up. In the training,
I should have brought my
it
manual.
was very deliberate.
But we
that
had
you
so
look at-
many follow-ups.
I know, but you can't pick and choose which one you want to use. There has to be a good reason for it.
Then I think we need to change this.
No,
So we don't get to change it.
Well, I mean, the wording here, because it says this admission / effective sentence. There's a difference between this admission and effective sentence.
Yes.
So
can we?
When you get to it, you let us know.
No, because you guys just keep going.
I know.
Take a breath.
I blame Wayne.
Because we had this discussion with
We
David
sure
Reagan after the training.
We had it with them when they revisited.
Yep.
Yeah. Institutional behavior focuses on the offender's performance while incarcerated. Community behavior focuses on the offender's performance while on any form of community supervision or release during the current period of incarceration. Work release furloughs or prior releases on parole during the current period of incarceration. I have to go dig
So
in.
when we had the discussion with the trainers, we talked about in Vermont, we have community supervision and we have incarcerative supervision. So a lot of times it's confusing because the STMF process didn't really consider that. It looked at whether they were incarcerated or on parole supervision, basically, community. And so the trainer said, when you look at the institutional versus community behavior, consider the most recent status. So if they were most recently incarcerated, that's what you're coding. If they're most recently in the community, that's what you're coding. Now, if there's some 2 or 3 day period of time where they just got reincarcerated, makes sense for us to look back.
I would have liked to have seen it at, if we're going to do it just by their current status and not consider any of the stuff that led right up to it, I would like to at least see 6 months, because anybody can do 3 months okay in the beginning. There's a honeymoon period sometimes. So
I put my,
Okay. I found
And so
it
remember,
finally.
it's coding, not scoring. So you can put whatever you want in the note part of it and explain, some thoughts that you have towards that. And then in the end, you're looking at all of the domains combined as to how you're going to decide one way or the other.
Yeah.
So this is the question that we asked Abby and David Reagan. Say someone is returned from furlough, but it seems like they've done some programming, otherwise learned about what got them returned and are trying to address that. Should this be considered in the offender change domain? Oh, and it says, yes, their violation can be considered under community behavior or criminal history, but their growth since then can be considered an offender change. So I remember it being that, I don't have all the details, but I remember that whatever brought them back into jail is to be considered in community behavior. It's not just, I think you have to mesh the most recent, and I don't think we ever came up with an exact time frame.
He was returned 4/9/24 for refusing a drug test and missed appointment.
Because I don't think we're not going to capture the return at all.
yes, you are under ability to control behavior.
Right, category 2.
Yeah, that's where I captured it.
A lot of these you get the double dip anyway, so.
Right.
If I remember the conversation with
It
was that he left it very ambiguous.
That's where
I
self-control.
don't think we had it was not cut and dry.
It was not cut and dry either
You had
way.
to use your opinion and how you wanted to do it, but it was.
But institutional community behavior is really about their disciplinary reports or sanctions if they're in the community.
I can do a little bit more digging too.
On to my next one.
Then Aaron Morris is next.
Oh,
This one's Pat Wayne and Sam.
So I should have put mitigating or neutral for the release plan.
Hold on, can I hand this out, please?
What did you put?
I put aggravating,
Don't
but I don't
mess
know
up
why,
yet.
because he's on
We could be
iPod.
right, we could be right.
to
No,
support.
if you want to stay
No.
consistent, you gotta go neutral.
No,
Don't
this
worry,
one
Wayne,
is
is that
not. This one's
Yes, that's right.
Yes, that's
Aaron
Wayne.
Morris, AM.
Oh my God, 2 of them?
Listen, I got like 3 last time.
I'm highlighted twice?
Oh, you've been highlighted a lot more than twice, Wayne.
It was all the same hearings.
Oh.
It was all the same hearing day in July.
I blame Sam.
Morrison, where were we?
I'll take it.
So in
Today will be my day.
So in release plan, I have Pat with mitigating, Wayne with neutral, and Sam with aggravating.
I should have gone with mitigating or neutral because he does have a good release plan to a support at his mom's in Massachusetts.
Correct.
So I
That's
should
why
have
I put
gone
mitigating.
lesser than what I did.
And Wayne put neutral?
Yeah.
What's the neutral one?
I did.
I probably would have gone neutral too, just because there's a plan, but like, how do we know ICOTS, like where he's going to be is going to follow through with that and get.
Well, it hadn't been approved, number one. He's planning on it.
Will
We talked
ICOTS to
about it.
reside with his and work with his mom in
It says
Massachusetts?
was
It
approved.
says
He had-
was
He was
approved,
approved. And he was
Aaron-
gonna work and reside with his mom.
which is his greatest support.
Nice going, man.
Listen to me jump down your throat now.
But he had not been approved. That was the plan. That's what he was talking, the plan.
I can tell you in a second.
Oh, it's underhanded. This must be a Bennington case. Think, right?
Yes. He has been paroled, so I'm gonna assume it was approved.
The guy that was on parole in Mass
No,
prior.
he was incarcerated this time though, it looks like.
Pat, you have mitigating?
Yes. And I've got will ICOTS to
Yes.
reside and
Well,
work with his mom.
There wasn't a,
There's a hint in my sentence that says requested to ICOT to Mass.
there is a transfer request reply. He was approved. We wouldn't have put him on the schedule if he
Right.
wasn't approved for ICOTS.
And to me, that was mitigating.
Good plan.
Yeah. Yes,
It was.
Sorry, Wayne.
Yeah. Hmm.
We all make mistakes, Wayne.
Yeah, I guess, but.
I make lots of them.
Well, Wayne did neutral. I wouldn't have called
Yes.
that a mistake.
No, I'm not, I'm kidding.
No,
Nothing has
it's
changed.
just,
It's right in the parole. I
it's a
just,
plan. It's no action. So that's why I was
But for
neutral.
ICOTS, you have to get approved for ICOTS. You have to have a plan. They have to take you like.
so I have a question then on that statement, Wayne. On,
Oh,
for release plan, so anybody incarcerated, what would their action need to be? Because this is a plan, so what would their action need to be?
All right, I surrender. Glad his mother was there testifying. Oh yeah, he's welcome back home. I'm glad his former
There you go.
parole officer from Mass was saying we welcome him down here for the third time to be on parole in Mass, but this is good.
No, I'm just asking. I'm just.
He surrendered. We gotta let him go.
He's waving the white flag.
Based on what Wayne just said, I would almost lean more towards neutral than mitigating, just because it just seems.
I'll say I would disagree because ICOTS, unless they changed the rules dramatically since I left, was
Okay.
they had to have a place to, before they would approve them, there had to be a plan approved by the other state, which would include housing and everything else goes along with it.
See, why I'd say neutral is the individual has a concrete, specific, realistic release plan addressing some of the community stability factors with several factors. I mean, I don't know, I don't remember, but yes, he has somewhere to live with family, but has he addressed some of his treatment? Does he have all that set up?
You can make a case for either.
I think you could do mitigating or neutral.
I probably would have done neutral, I think.
I mean, mitigating has to be like a 5-star stellar. I got all my appointments set up. I'm ready to roll kind of thing in my mind.
So Sam, if you haven't checked off aggravating on this, we wouldn't have had this discussion.
Nice going, Sam.
I thought that I would make it.
Thanks.
That's why I said
A
I
nice
blame Sam.
time.
Yeah, thanks for
I-
nothing.
That's good.
Yes.
I bring it up and then I'm quiet and
It's
I
good.
listen to everybody
Yeah,
else talk.
right.
Why did
That's how you learn.
Aggravating.
I don't know. I said that when we first brought it up. I don't know.
Yeah.
That's why I
You're
have
right,
to
it
do
should
my
have been
notes.
neutral, right?
You didn't have the benefit of going through all that.
Well, if you look
Yeah.
though, Wayne is
Yeah.
referring to his notebook, not his SDMF sheet.
Oh,
I didn't bring my notebook.
I have a system.
Okay.
Gonna say your special notebook, Pat, that we have to buy for you.
I always have-
You can't use the regular flip pads.
You don't buy my
I
notebook.
start here. and
Oh,
then
we
I-
used to buy you
Oh,
special notebooks.
I have, no, I go to the dollar store and get them.
Oh, nice.
Wow.
You haven't done that for a long
No,
time.
I don't know. I don't know.
No,
Okay.
Christopher Kozmowski.
All right, I'm going to aggravating. I messed up on that one.
Well,
not necessarily.
here's the sheets.
That's the name from the
Well,
past.
He had, yeah.
So I
I
have
did.
Pat is aggravating. So this is institutional community behavior. Pat aggravating, Wayne null, and Sam mitigating.
You did it again. I know. But
and this is
he does have recent DRs that I didn't.
2023,
23 and 2024,
but that
Where
one he
are
was
we?
found not guilty of,
right?
so they didn't consider it.
That's true.
I've got major B20 less than a year ago.
Okay, so
That's
what
right.
was what's a major B20? Do we know?
I think it says it in here.
I have to find this parole summary.
That-
I think
Following
it said
orders,
it
maybe?
in here.
So this is where serious.
I
This
don't
is where
know.
serious comes into play. If
I
you
think-
consider all serious is
Was issued a major B20 and pled not
Misuse
guilty
of
and was
meds.
found guilty at the hearing. I don't remember now what it was, but I think we asked.
I think that's facility
We may have
rules
asked.
or following, I think facility rules not following orders of the officer. But I could be wrong.
I don't remember now.
I'm just curious of.
Do you have it?
I'm gonna look it up.
Oh, okay. I didn't know if you,
Our recent misconduct at any
So
time.
Sam, you
Did I
indicated
misread
mitigating.
something?
I had
They didn't do
mitigating.
it yet.
What?
Put anything right.
I got 39 total DRs. Most recent one was 14 and 24.
they dismissed that
They,
one.
he was found
So
not
that didn't
guilty.
He
happen.
was found not guilty.
So it didn't happen.
I don't
I
know, but he was found not guilty, so I can't consider that it happened.
Why not?
Because that's kind of
Because
like
they may have
violation of due
reviewed,
Because you're
process.
innocent till proven guilty.
they may have reviewed it and
Right.
found,
We're not
no,
on
we,
that
Maybe
standard.
you did it.
we did that by, in error.
He was on his third significant furlough interrupt. Oh my
We
gosh.
paroled him once and it was like the biggest, he had all kinds of supporters from the victim's
Yep,
family.
I
there.
remember the case very well. It's a.
And he has absconded each time.
He has a 4-year interrupt too,
Was a very vicious.
which
thing
is
that happened.
nuts.
My goodness.
It's in a 4-year.
Murder in Bennington, remember?
Yeah.
He was the.
Yeah.
Yeah.
Wait, which one was he?
that's my-
Which murder was it?
He.
How long ago?
He and his buddy were friends, were working for this family.
NATO
His buddy
Weiser.
killed the person in the house and Kosmowski was there. So he wasn't the perpetrator, but he was there.
Is he an accessory?
Right.
When, what year was that?
2006.
But in jail, he.
Oh, that was,
Renito Weiser.
I don't, that's not ringing a bell
No, he
for
was,
me.
it was a very vicious.
That was the
offense.
big,
I'm sure at the time I knew about it,
The
but
network is so
What was
slow.
the violation?
Wow.
it's in a 4-year.
I
interval.
think it would be better in the
for the
office.
third time.
This is a parole.
Pro hearing? Okay. I see he was not granted, I think.
It was an in-person record review.
Yeah.
Okay. Oh, he was doing. Venture shifts with the inmates there, everything was, he was doing everything. He was-
Yeah, yeah.
The treatment set up, if I remember correctly.
He went out on furlough, was doing well.
So
The
he-
victim's family came over from New Hampshire and then he Messed up. So what's our debate? So our debate is over mitigating versus
Yeah,
aggravating.
we were looking to see what B20,
Yeah,
major B20.
Trying.
Misuse of meds.
She's got really nice handwriting,
Okay.
I must say.
For a guy.
You don't see handwriting like this usually. I don't know if somebody wrote
It was
or what, but
diverted
it's really nice
MAT.
handwriting.
Very good.
See that a lot.
Just got drug tested recently.
Wayne, where did you see it
Is
13
he still
DRs?
currently incarcerated?
Where did you see it
We
13
didn't approve him,
DRs?
right?
No, there's a record history.
Total
Okay.
39.
Get a
DR
long history, yeah, DR history.
Okay,
And
thank you.
Total 39.
Do you know about the category of offender? What does it say? Offender?
Chain?
No. Up in the,
Discipline history?
no, on our report, not the reports, but when we get our,
Summary?
Like
Let
on
her,
the-
let her come up with her own term.
just a
Give
minute,
her a minute.
when we get our, the list of cases,
Yep.
okay, and we go into the individual case,
Mhm.
up above, it'll say offender
Files?
history?
Yeah.
What's that offender history?
Offender
Offender files.
Yeah.
Do you ever go into that?
Oh, the offender file, yeah.
I do,
Yeah.
Okay.
unless it's their minimum, then we don't usually
You
have.
can read
an
about what
offender file.
happened to them before.
What, get their
Okay.
whole history of before.
And he had a long, he had a long.
I look in that a
Okay.
lot to see their
Especially in
behavior.
violations, if we grant them
Yes.
parole.
Yeah.
Okay.
It has
Once
whether
before.
they've been on parole before, whether
There's a
they've
bail
had
hearing.
violation
We- we- we
hearings.
go through that.
Okay.
They'll hear the
Yeah.
That's good to
information.
know.
Oh, I go
I
in
don't know
it,
if I've,
I go into it a lot.
okay,
So,
that's good to know.
Yeah.
so the DR history that's in the report, if it's attached to the new reports now, that's where he would have got his 39. He would have, Wayne
Yeah.
goes through and counts them all.
They can
Okay.
come back for 15 years.
And it depends on how far they go back too. You might just get this booking, or you may get like 30 years worth, or you may get a year's worth.
Okay.
So
All right.
Did you find the B20?
it's
Yeah,
diversion of an
Yeah.
MAT
Dean was
meds.
right. They already have that.
Well, that's why I put
He was
aggravating.
denied.
Yep. I was incorrect in mine.
Wayne, what would you have scored?
You didn't score. What would you have scored it, Wayne?
What, did I?
You didn't
You
score anything.
didn't.
No.
What would you have scored it?
Didn't.
I'm gonna guess he would have put an A, but
Well, now that you tell me I can't use all that, I guess I'd have to go neutral.
no,
She likes neutral.
But
it's the
No,
most.
we're still split on that because I'm kind of with you on
I'm
this.
still saying this is just total history. I would have put aggravating.
I would do
And I
recent
checked the
history,
right
but
box.
I should have done aggravating.
I would look at this as that he's been incarcerated for X long since his furlough revocation, and he can't behave.
Right.
Mm-hmm.
That's his most recent.
Yep.
Yeah, aggravating for me on that one.
Absolutely.
Yeah,
I didn't put it on the schedule, but do we want to expand now that there's more parole summaries coming out? They're supposed to, the Word versions are, maybe some will be coming in September, but by October, we probably will not have any Word versions anymore.
Oh, really?
but did you find it interesting, MJ, that
But
other than my faux pas, the other three, they are all consistently across the board, all categories?
mhm,
I thought that was kind of cool.
yeah,
Are you cheating?
It's not just one, it's just not one letter off, it's consistent, each one of them minimum, aggravating, and neutral between the.
Equal opportunity, huh?
Oh, boy.
The meeting digressed by 11:45. Okay.
so do we want to move on to more, or
Is there any more left?
what did we, no. What
Oh.
did we decide? I think one of the last staff
You
meetings.
got us
we
up to 4, right?
We got us up to 4 or however many. And then we decided that once we had the new parole summary fully in, then we'd do all.
Mhm.
Yeah.
And we're gonna be fully in probably by October.
Okay, so we'll start
Okay.
October 1st.
With October hearings.
Mhm.
There's one day that's gonna be the worst, and you're all gonna be trying to pull straws with Dean to not get on that one day a month.
Is it the Bennington day? Because if it
They
is,
don't
I don't
know.
have to worry about it.
They should know based on the schedules which day is the worst one of the month.
I don't even know. Is it one I'm not usually on?
Uh-huh.
Oh.
Is it Rutland?
No, it's the northern day. It's the
Northern.
northern Wednesday day. That's all
I'm on
parole
Northerns,
hearings.
aren't I?
I know.
Yeah, you've been on that. It's the last
Yeah.
Wednesday hearing. That one's all parole.
Oh, maybe I was only on it like
Oh.
once.
Yes.
Remember we used to go there and we'd get there and they'd all wave after we got there?
Yeah, yeah.
We never waved when you came to Rutland. I guarantee
They
you.
have-
No, I know.
I will say
We
that
go to Newport, and
northern,
we'd bring a turbo. We'd bring 6 of us in up there and have 2
Wow.
boards going, and then half or
Really?
3/4 would wave.
Yeah.
I will
Lunch
say
at
that-
11:30 downtown.
I will say northern has one of the best
I wish we
systems.
did
Do they?
do some of them still.
Why?
Because they have everybody, they're now doing it in the visiting room. They pull up the caseworker and the person, then they have another caseworker in the back of the room gathering everybody else, and it's just between them and Barry PMP, it's just
It
it's
runs
just
smoothly.
the
And there's others.
constant.
And
Yeah.
there's others.
Then there's
There's a lot of others
Yeah.
that it's not so flowing.
Do we not have a waiver day?
We do not have an overflow day in September because it would have been on the 26th. I figured we could schedule one if needed. Or we can move it to another day that month if you want. That's up to you. We haven't needed an overflow for the last 2 months, which is great, but I like scheduling it. But because we moved
Yeah.
staff meeting to Thursday, we could do a Tuesday.
I was just thinking of the Tuesday, just to have it there. And you'll have people scheduled in case you need it.
Yeah, I can do that too, because I'm normally on Tuesdays anyway, so my schedule's already blocked at work that day. So if you need someone for that overflow, I could do the
If I have a facilitator that day, because I will be at the Northeast Jail that day at the LUS meeting, talking about the new parole summary.
You have to make bail or something.
Maybe.
We'd parole
Think
you.
she was
I guess.
RTF?
I don't see scoring past history, but
So we can just tentatively do that and we'll go from there.
All right.
the 5th and the 10th, Dean, I wouldn't be available.
Okay, let's start with the not availables. Tom is
5th and the 10th.
Sam,
I'm not available on the 3rd.
Wayne,
I think I'm open, but I'm waiting for my slower than death phone to reboot up to look at my calendar, but I don't think I have anything.
okay.
You say that.
I'm all set.
There we go.
I'll give you Lynn's in just a second. She had a doctor.
So Lynn, unfortunately, she's not here now, but she had sent me a note that her new part-time job, I guess, is a little busier than she thought it was going to be. So she's Thursdays only at this point.
I'm good for all the Tuesdays, and then I'm also available on the 20. We're not doing any on the
24th,
25th,
the
right?
overload day.
We're not doing
The 24th. Wait, no, sorry. Yes, the overflow day on the 24th.
It's a Tuesday anyway.
But then we're not doing any on the 25th?
No.
No.
I was gonna say I could do the 20th, but I can also do the 19th, Thursday, the 19th, I can do.
Any Wednesdays, Katie?
The 25th, but we're not doing it.
You'll be alone.
So Dean, I can give you Lynn. She put it here. She said, I'm only able to take meetings on Wednesday or Thursday moving forward. I cannot do Wednesday and Thursday in the same week. So you can't, she can't do both of them in the same week, but she could do a Wednesday or a Thursday. And she's not available the 10th, the 11th, or the 24th. That helps.
Yeah.
That's better than.
I told you the 19th I could do, right?
Yep.
Okay.
No Wednesday skating, right?
Not this month.
Okay.
Just the extra day that I could do, I picked for that Thursday.
Okay.
Based on what my client load looked like.
Sounds good. And we've got, as everybody knows, Richard coming on the 26th, so that will be a full day of training.
Don't have an agenda yet, but I'm going to connect with him at some point.
Okay. (2025) schedules.
I just wanted to just put it out there because I realize it's the end of the year. You'll be seeing them soon. I will be putting them together.
Coming soon. And you moved Burlington to.
Oh yes, Burlington has been moved starting in October. Burlington is going to be moved to Wednesday. So it's not just going to be Burlington PMP violation hearings. It's going to be all Burlington PMP. Because when we moved Bennington to that Thursday, it's put us over, and I've ended up moving Burlington to Wednesday 2 months in a row. So I asked them, and we're just moving them.
Even though it says Burlington, they will not be on.
October, starting in October.
Okay, not until October.
They wanted another month.
Okay.
So.
Good.
Trying to juggle
Sounds good.
it all. The only hearing day that usually is light is the Hartford Brattleboro Day.
Yeah.
Anybody have anything else? MJ? Carl?
I don't think so.
All right. Thanks, Colby.
Thanks, Colby.
I have a motion.
You're welcome.
Wayne has a motion. Adjourn.
I'll second.
Motion made and seconded to adjourn, even though we don't need to vote on it. It's always nice.
Oh, I
All
thought
in
we
favor?
did.
We did too.
Non-debatable.
No, not a debatable motion.
Non-debatable motion.
Very good.
Oh, okay.
Listen, I've been chairing too many meetings. All right.